Committee on Elections will come to order. The clerk will call roll.
Smith.
Here.
Busey. Burrows.
Here.
Capriglione.
Here.
Deala.
Here.
Manuel. Morales.
Here.
Swanson. Vo.
Here. Quorum is present. As a reminder, anyone present wishing to testify before the committee, please register at the kiosk located in the hallways behind the hearing rooms. If you require assistance in registering or testifying, please contact the committee staff. You may not see it now, but due to the number of witnesses we will have registered and to accommodate all who wish to testify, there will be a time limit of 2 minutes per witness during the public testimony period. Committee members, please remember to check out the publicly available comments. These comments are important. They're left by the public on each agenda item in our hearings. Comments are open until the end of the hearing and are posted upon adjournment from our hearing.
Do you want to go straight to number 9?
The chair lays out Senate Bill 1039 and recognizes Representative Toth to explain the bill.
Thank you, Chairman. Members, irregularities happen in every election cycle in every county. 2016 saw Democrats calling out election irregularities, and in 2020s, Republicans called out election irregularities. Currently, there is no mechanism to require an election office to explain any irregularities for those who are intimately involved in those elections, and yet Texas law demands that we maintain the integrity of that election data for 22 months. A candidate, election worker, or party chair, or proponent or opponent of a measure can send a request to explain an irregularity, but there is no requirement that that election office respond. In the end, it causes all of us to lose trust in the foundation of our democratic system. In Harris County in 2022, there were election irregularities that were pointed out, yet nothing was done. And again, it further undermined our ability to trust our election system. Committee Substitute SB 1039 is a vehicle for those who are actively involved in elections to get answers, shine light on the problems, and get election irregularities solved. And with that, I ask for the opportunity to close.
Members, are there any questions? If not, we'll go to testimony. Reserve the right to close. The chair calls Laura Martinez. Laura Martinez. I show Laura Martinez registered as against SB 1039, testifying on behalf of herself and not here. The chair calls Chris Davis.
Morning, sir.
Good morning. I show you as Chris Davis here against SB 1039 and testifying on behalf of the Texas Association of Elections Administrators. Is that all correct?
Yes, Mr. Chairman, it is.
Yes, sir. Go ahead.
Thank you, sir. When we read this bill, and we've debated this bill, we being election administrators, some county clerks, we recognize the need perhaps for a centralized authority in terms of making sure that counties are following law and that we all want minimization of irregularities. Going through the bill and bills like it, it seems like it's a reactive punitive measure to reactive punitive measure to reactive punitive measure. And some EAs in our talk about this bill wonder where any preventative measures may be. And when I say that, I'm referring to specifically mandated education hours for election administrators. When I Google mandated continuing education requirements, statutory mandated hours, when I Google that, Texas Association of Counties has a helpful page where literally every position in a county, from county judge, county commissioner, county clerk, tax assessor, collector, all the way down, constables, JPs, all have statutorily mandated education hours. Election administrators do not. And I think they need them. And we think that could be a preventative measure to prevent counties from even being in the position of having to answer for why they did do something or didn't do something. Whether they're counties that have all the resources in the world in Texas, or next time, those counties that don't and don't have resources, money to attend in-person SOS training, Texas Association of Election Administrators training. So could there perhaps be a way to include or incorporate mandatory education hours for county election administrators like almost every other county elected position has? So county commissioners' courts are probably forced to budget for them, because we're seeing that many county commissioners' courts don't. With that, that's the extent of my testimony.
Vice Chair Busey?
Thank you, Mr. Chairman.
And by the way, I recognize Vice Chair Busey as being here, so, which we have to do.
Yes, sir.
Thank you, Mr. Chairman. Mr. Davis, right now what happens when somebody from either party or a candidate calls your office and has a question about an election procedure that was applied? How do y'all handle that currently?
Y'all being me, Mr. Vice Chair, or generally, we get to the bottom of the issue. We try to suss out what the concern or question is and try to determine whether it's legitimate or not. If it's a concern or question at the polling place, we try to check with that presiding judge or that deputy early voting clerk to see what may have occurred and try to get to the bottom of it. Oftentimes, the overwhelming majority of times, that investigation or that review suffices for individuals, be they candidates, chairs, PJAJs, or PAC heads, suffices. Sometimes it doesn't. And sometimes those folks reach out to the Secretary of State's office. We appreciate that this bill kind of funnels those concerns to that local county level first, because I suspect the Secretary of State would say they get tons of complaints, concerns from folks that have jumped that county level. And they're as limited in staff as any of us are. So trying to handle it on the ground level is important. And we respect that about this bill.
You just said they're limited in staff as anyone are. What is the cost do you think is going to happen for y'all to be able to handle this, EAs and clerks? And I think especially what's the impact going to be on our smaller counties where they're even less staff?
That was a part of our conversation we had amongst DAs, Mr. Vice Chair, in that our hope is that any kind of request to address, well, irregularities or production of information, if it requires labor, that it be handled just the same as any other kind of request for information under the Public Information Act. That if there requires labor, we're then able to charge for labor. There was a concern among some EAs that this may be an end around to being able to charge for the labor required for producing some information for individuals in this list that ask for it.
Is there any limit that you see in this to how often they can? I mean, I'm worried about just, bogging down the system.
Well, for a particular issue, as I read it as a non-attorney, a limit of 2 requests and a total of 30 days before it's brought to the SOS's attention. But for other issues, we share that concern of just perhaps an abuse or a weaponized process of, there's a perceived irregularity. Because I think, appearance is even the word in Section 1, that perception of irregularity when it may be there or may not be there. That could be problematic, yes.
Thank you, Mr. Chairman.
Yes, sir. Members, any other questions? Thank you, Mr. Davis.
Thank you, Mr. Chairman.
The chair calls Robert Green. You're Robert Green, sir. You're here for SB 1039, and you're testifying on behalf of the Travis County Republican Party Election Integrity Committee for Legislation and yourself. Is that all correct?
That is correct, sir.
Go right ahead.
When audits can be ordered, that's what this bill is all about. It's all about election integrity and being able to identify problems that may exist in the procedures. This bill goes directly to the heart of election integrity and to instilling public confidence in the accuracy of elections, addressing irregularities via inquiries and requests for pertinent information about them. hope that it would deter election officials from behavior that would be considered irregularities. We must hold the election authority responsible for those election irregularities identified but not sufficiently explained by those election officials. Notice of audit and results, notice of results to parties. That's an important part of the bill, that if there are problems, that they are then reported to whoever may have made the complaint. And then if this goes through the entire process and the violation is determined to have been valid and have occurred, there is an ability to appoint an election conservator for significant violations of the TEC. And if it's considered, they can appoint a conservator to that county for the next 2 federal election cycles. If you have any questions, I'll be happy to answer them.
Thank you, Mr. Green. Members, any questions?
Thank you, sir.
You bet. The chair calls Christina Atkins. Good morning, Ms. Atkins. You are the Director of Elections and here on behalf of the Texas Secretary of State's office and neutral on SB 1039. That's all correct?
Yes, sir.
Remember, she's here as a resource witness, of course. Anybody have any questions of her?
Just a quick one.
Yes, sir.
The way I read this, it appears as though, someone who is, within the system, that is a candidate or working an election, in the process, what it provides is a mechanism internally to say, okay, I've got this question, answer this question, or concern or something, and absent that, then, and only then, it goes to the Secretary of State. Is that your understanding of kind of basically how this functions?
Yes, sir. I think at its most basic level, I think right now, we take complaints from anybody that wants to submit a complaint to our office. That process still exists, even with this bill. Anybody can submit a complaint to our office. What this does is it provides for a defined group of individuals the ability, it directs them to go to the county first to seek the resolution through the county and get that information through them or the elected official before it comes to us. So I think that when it does come to us, we would have a little bit more information about the circumstances, and it would give the counties the opportunity to speak to the issue, whereas sometimes when complaints come directly to us now, the county may not know about that issue.
Right. The process here seems to keep it local, and then if it can't to the satisfaction of the person, then it becomes, a process for the Secretary of State to get involved. Is that?
It provides like an escalation path where we can review it.
Okay, thank you.
Yes, sir.
Yes,
Sure.
Vice Chair.
Sorry.
Sorry.
Just a few questions about the bill. One, we've had other bills that deal with oversight and conservatorship, but what is your understanding of how this bill would work as far as your role?
So, as we were discussing, Representative De Ayala and I, this is forcing the select individuals that have a role in the election process to try to resolve the issue with the county or the election official directly. Then it escalates and comes to our office, where our office has the ability to audit the particular issue. It's not necessarily a broad audit of the entire county, but it's auditing specific identified issues that are brought to us. At that point, after the audit is completed, there are some other potential measures in place that could provide some additional oversight, like a conservatorship or even violations. Or if a violation is determined, there could be a penalty that's assessed. I think in contrast to some of the other bills, there are other bills out there that we've talked about that have a little bit more of a process before that. Where there's an opportunity to provide some training opportunities or to provide some oversight before we get to that point. This is targeted to very specific issues.
Would the conservators under the statute be managed by your office in the election division, or do you know how that would, what's the functionality here?
So the language with respect to the conservatorship, there's not a whole lot of words on the page right now with respect to the conservatorship. The way I read it is it would be directed by our office, that we would appoint the conservator. And so I think since we're the ones appointing the conservator, we would have to provide some parameters as to what the conservator, what their role is and I think what that process would entail.
Will this be someone you would send out on site, or?
I'm sorry?
What would that look like in reality? Would this conservator stay here? Would they go out?
I think that's a great question. That's I think probably a combination of the two. Depending on the issue itself, and it's hard to, I think a lot of this is going to end up being very fact-specific depending on the issues that are identified. But what I would envision for a conservatorship in this scenario is that we'd have some identified issues. A conservator would be appointed. The election officials or the election department would be required to work with that conservator and consult with them when they're making decisions related to the election process, and that conservator would provide some oversight. I think in some cases that would definitely be on the ground for certain time periods during the election process, but I don't think it has to be a full-time position. I think this is something where you could have somebody that provides guidance, remotely, but is on the ground, on site during select periods.
Would y'all need money and staff to do this, to be able to implement?
Yes, sir, there was a fiscal note on the bill,
Okay.
and so that is accounted
So
for.
y'all, it is accounted for?
Yes,
Okay.
sir.
All right, thanks.
Members, any questions? Ms. Atkins, I apologize. Is irregularities, is that a defined term anywhere in this code section?
Irregularity is not defined, but I can tell you that generally, we talk about irregularities a lot in the election world.
Yes.
And an irregularity would be a violation of a statute or a variation in a procedure that doesn't typically have a criminal penalty attached to it. So we're not talking about a criminal act, we're talking about somebody not following a procedure properly. So they're not following the election code, but they're not committing a criminal act.
And the idea of a custodian, is that on page 4 here? I guess you're gleaning that from, if possible, remedy the violation on behalf of the county clerk or other authority?
The part where, are you referring to the part, sir, where it talks about our office being able to remedy certain?
Yes.
So I think that there are probably a limited set of circumstances in which our office would be able to remedy something on behalf of the county. My guess is probably the most obvious scenario would be certain types of list maintenance activities with respect to voter registration. If there are voter registration issues that come up and there's a county that hasn't been handling some of the issues properly, maybe not canceling registers that should be canceled, where the statute may dictate that they're canceled, but they're not canceled. There are, I think, things that the state can do on behalf of the county to remedy that. But I think it's going to be a very narrow set of circumstances.
And in this particular situation, it would be after the 30th day after the clerk received notice.
Yes, sir. Yes, I think there's a process here that I see where we are providing notice to the county of the findings from the audit, what we discover, and it gives them the opportunity to take those actions on their own before the state steps in.
Okay. Members, any other questions? Representative Morales?
It's too early, Chairman. Good morning.
Good morning.
All right. So I heard the discussion about issues, and then I also heard the chairman ask you with respect to the issue of whether irregularities was defined. Do you think that we need to include the definition of irregularity, or that it is general enough in your world, Secretary of State, so that you can feel comfortable as to what you should intake and what you should not address?
I think that in the election community, the term irregularity is a term of art. And so I think that we as a community, the folks that work in elections understand what the term irregularity means. I mean, adding definition is always something, I would never turn away from people providing more definitions, just because it helps folks that may not be, in the practice of reading the election code every day understand what those terms mean. But an irregularity is going to be any violation of what the statute dictates that you do, but it's not typically a criminal issue.
Yeah, and I guess that's where my concern lies, where there's a certain number under this bill of the individuals that would be allowed to then escalate this to the next step, right?
Yes, sir.
As far as making a request. And if that is the case, obviously, these folks are either the candidates or local elected officials. And so I can foresee the possibility of pressure at the local level that individuals, constituents that they have may have in their eyes irregularities, but they do not necessarily fall to that threshold at the Secretary of State level. And so I'm wondering if it would be better to have a more definitive or the issue a little bit better defined so that we are just not considering baseless allegations or just allegations. Are you going to need something more than just an allegation with some proof before you can start that process of investigating and conducting the audit? Or basically any request is your position, any request that comes in from these individuals that can make such a request, will you consider valid and then have to put the Secretary of State's office through that process as outlined in the bill?
I think the bill is a little bit more narrow than that, sir, because I think that, you have a filtered group of individuals that can bring this complaint or bring this issue to the county. The county is required to investigate that and provide any supporting documentation for that issue, if necessary, to support the allegations that were brought to them. At that point, it comes to the Secretary of State's office, and I think if it's on page 3, subsection B there, it says that the Secretary must determine whether the information submitted under subsection A, so the information that comes to us, if they don't have a sufficient answer from the county, then it comes to us. We determine if that information submitted sufficiently explains the irregularity identified. I think that most of the time when issues come to us, they're going to be resolved right here. If the counties are doing their work and they're getting the opportunity to explain issues and investigate things that happen locally, that information comes to us. If they provide a sufficient explanation for what the irregularity was, why it occurred, and potentially how it's going to be remedied, that's the end of the inquiry. I mean, it stops right there. It's when that information does not sufficiently explain what happened. That's what triggers the audit. So I think by and large, most issues will be resolved at that point in the process because the county's already doing the investigative work prior to that.
Yeah. So just taking a general, somebody makes an allegation, paper ran out at this polling station at 3:00 in the afternoon.
Mm-hmm.
Is that sufficient to trigger then an audit and investigation on behalf of the Secretary of State? I understand that the local level has to respond, but what if they just say, no, we didn't? And we still had 1,000, copies or paper there at that polling station at 3:00.
So that's one that I think, that's a good example, and that I think there's a data-driven approach to that. I think that when an allegation is made like that, it's important to look at what the data says. There are data points in an election where you can look to see, how many voters checked in at a location, if there were gaps in the check-in process. There should be chain of custody paperwork that shows you how many ballots, blank ballot cards, or actual ballots themselves were distributed to a given location. You have a way of evaluating just looking at raw data as to whether or not there was a problem at a given location, and I think you supplement that with maybe statements from the individuals involved. And so I think you'd have to look at all of those points to determine whether or not you need to audit the issue. If somebody brings that allegation to a county, the county doesn't look at all of those points, doesn't look at the data there, doesn't get statements from the individuals that were involved, and just says, nope, no problem, then at that point, I would say that's a good example of a situation where their response does not sufficiently explain the irregularity identified. And at that point, that would give the Secretary of State's office the ability to begin an audit of that identified issue, and I think it would compel the local election official to participate in that and provide data to our office to help resolve the issue.
Got it. So in that process, it entails that at the local level, the individual tasked with having to address the complaint has to have an initial investigation and come up with some conclusions and then put them in writing and send them over. Do you think, based on some previous testimony earlier this morning, that we're going to need to provide additional training to those folks at the local level so that they can know how to conduct an investigation and include their written findings, or do you think that they have sufficient training right now to be able to perform that duty?
I think I would always encourage training opportunities. The more training that you provide, training and education promote voluntary compliance. And so I think the more training that you provide, the better our election officials are going to be at their jobs, and the more willing they are going to be to engage on these issues.
And do you believe that training should be incorporated into this bill?
I think that's a possibility. That's a decision for you all on this part, but I would always encourage training.
And how many, in your analysis, to come up with the fiscal note as to what this would entail if it were to pass. How many audit requests that you estimate you would have per year?
So this is interesting. The fiscal note on this, the original filed version of the bill had it mandatory that we appoint conservators in certain situations. This makes it the committee substitute that we're looking at now that got passed from the Senate, sorry. The one that came out of the Senate, the version that came out of the Senate, let me clarify that, sorry. The version that came out of the Senate changed it to a permissive situation. So we're not required to appoint a conservator. We have a little bit more discretion. So the fiscal note actually looks a little larger than it probably is in reality as far as conservatorship costs. When it comes to employees, we said that we would like to add 6 employees to our staff. We need several individuals to help review complaints and review the information that's provided to make these determinations as to whether it sufficiently explains the irregularity, and then some additional members on our audit team to handle these additional audit situations that may arise outside of the other statutory audits that they're providing.
Got it. And I saw the fiscal note at around $6 million. Is that the one you're talking about?
Yes, sir. It's, I think, probably a little on the high end. We did submit a revised fiscal note to LVB, but this time they just didn't reduce the costs on it. We could, because of the bulk of that was conservatorship costs, but I don't think the conservatorship costs will be as high now that the conservatorship appointment is permissive rather than mandatory.
Got it.
The chair recognizes Representative Manuel's here.
And I have also in my notes here, 30 days to cure at the local level, right? Or there will be a civil penalty of $500 as far as the possible implications here under the bill.
Yes, sir. That's the part that comes after the audit is completed. After we complete the audit, we identify the issue, we provide findings on that, and then there's a concurrent path here where we also, we notify the county of their findings, and then we could assess a civil penalty, and if it merits it.
Okay. And between I guess once it gets kicked to the Secretary of State, do you anticipate that has to be resolved within 30 days? Help me clear that up, because I don't think
I'm sorry, sir.
So
What part has to be complete?
So it goes up to the next level, right? It's not addressed at the local level. The response that they gave was not sufficient. And the candidate or a county judge, one of these officials is able to kick it up to your level then. How long before you all have to make a determination? Is there a time period?
I did not see a time frame defined in here. Oh, no, I'm sorry, there was. Not later than the 30th day after the date we received the request for the audit, we have to make that initial determination. So there's 30 days from the time that request comes in, but there is no time frame specific to how long it takes for us to audit the particular issue.
Okay.
That's undefined.
So the local official who had to respond to the investigation, once they're informed that this has now been kicked up to the Secretary of State and an actual more detailed investigation is going to take place by the Secretary of State, do you anticipate a letter from the Secretary of State to the local official, send me
Absolutely.
all of the information so that we can evaluate it and come up with a...
Absolutely. This needs to be a transparent process. And so anything that involves our office where we are going to be gathering information from our counties, for these particular issue audits, we're going to be very open and very direct with the counties as to what the responsibilities are for them in producing documentation and what the timelines need to be and what our role is in the process.
And at the local level, as part of your, I guess, fiscal note analysis, do you know if it was contemplated whether at the local level they were going to hire, those local entities were going to have to hire additional personnel to either conduct the investigation or also cross-check their auditing before an answer is provided to?
If I remember correctly, sir, and when we were working on the fiscal note for this, we did identify that there could potentially be some local costs related to this, but we can't estimate those costs because we're not the ones locally that would understand what it would entail. So that would be a question that you would probably want to direct to one of like a county election official. They could probably give you a better sense of what, based on their complaint volume, if they think it would necessitate additional staff.
Got it. Okay. Ms. Sherman, thank you. Those are all the questions.
Absolutely. I think do you have any questions? All right. Thank you, Ms. Atkins. Appreciate it.
Yes, sir.
The chair intends to roll on through this bill. fairly promptly. So we've had quite a bit of technical discussion about it, but I'm interested in finishing out the rest of the witnesses. No question, everybody's going to get a chance to express themselves. The chair calls Ed Johnson. Mr. Johnson, I say you're here on behalf of yourself and that you're for SB 1039.
That is
Is that
correct.
correct? Okay, could you?
Yes. So, you know, the intent of this bill is to help get answers to questions. Last election in Harris County, they counted 10,000 more ballot by mails than they actually received in the mail. So, problem here. Candidates have asked the question, how do we have 10,000 more votes than we've received in the mail? No answer was ever given. That's where this would help explicate the process of why are there 10,000 more votes than what you actually received in the mail. Ran out of paper in 120 polling locations. What was the misplanning there? You know, this would give them the ability, a candidate, the ability to audit that system of why did we have such a breakdown and not get paper to polling locations. Currently in the current election right now, Harris County has, was it Goose Creek ISD that they have miscoded and the boundaries drawn wrongly. And there are multiple voters that have been denied the right to vote. This would be another one where candidates could ask, how did we not get the boundaries correct on these districts for the election to start? This would give the tool for candidates to get that. Right now they're asking these questions and get no response. So this gives them a tool to engage the Secretary of State, get answers to these questions that are very important on how an election's run, and then be able to have a solution at the end of fixing this so it doesn't happen again.
All right, thank you, Mr. Johnson. Members, any questions?
I
Representative Morales.
do, and I guess this, I should have asked Ms. Atkins better, and I'm sorry, Mr. Johnson, if I put you on the spot, but
Sure.
other than asking the question, not getting a response, what's your understanding of how these irregularities are currently addressed? Do you then have do individuals have
Right
an
now,
ability to go to the
right
Secretary
now
of
they're
State?
going through an open record request most of the time. They're placed into an open record request. They say they have 10 days to respond. They say they don't have the information, and then the issue dies. There is no response.
Other than, I guess, a lawsuit, if you wanted to invest
Yes.
the money and the time and all
And
that.
that's very expensive on a candidate to have to go file a lawsuit on this. And a lot of times, you know, you've been in elections, you've spent every last dime trying to win that race, and now you got to come up with another couple $100,000 for a lawsuit. That gets to be really difficult for a candidate.
Are you aware of if our constituents have like a Secretary of State, 800 number that they can also call to submit their irregularity to see if they
The
right now
Secretary of
currently
State has an 800 number. You can call it. and they answer it usually on the first ring. So they're very prompt there and get action. They have a whole legal department. When you call, you can push 2 or 3 on the dial and you go right to their legal department and they can help you answer questions on that.
And in that process, do you think that they've done a sufficient job to be able to address whatever irregularity has come up from the local level, or do you think that
Yeah,
this
so
is also necessary?
Currently in this past election cycle, there was an audit that was supposed to be conducted of Harris County, and Secretary of State stepped in to help conduct that audit of the county, and the county refused to give them all the materials they needed to do the audit. And so it left the Secretary of State now and has to maybe possibly pass a lawsuit against the county to get the information they need to get the audit. This bill would fix that. It gives the Secretary of State the leverage to get the information they need to conduct an audit to find out if there are problems with the election.
Understood. Thank you, Mr. Johnson.
Members, any other questions? Thank you, Mr. Johnson.
Thank you.
You bet.
Sure.
No, you have.
Is part of this, is this in the ongoing lawsuit right now that's happening? Is this question of the elections part of it, is this in the ongoing lawsuit with Harris County to find out what's
I'm not involved in the lawsuit. I know there's a lawsuit going on, and I know the candidates that are filing feel that they did not
Right.
get answers, and so they have had to go your route, and they've had to file a lawsuit to get answers to these questions.
Perfect. Thank you so much. Thank you,
sir.
Chairman.
You bet. Thank you.
Thank you.
Thank you, Mr. Johnson. Chair calls Susana Carranza. Susana Carranza. There she is. Morning, Ms. Carranza. Good to see you. You're here on behalf of yourself and you're against SB 1039.
Yes, I am. That's all correct. Good morning. I wasn't expecting this bill this early. So, a couple of things, a little bit repetitive, but reemphasizing this is punitive, not preventative. But also, I find it interesting that last week, we had a whole discussion of removing the EA position from a certain county because thinking that elected officials should be in charge of doing this, so because they're accountable to the voters in elections. Yet this bill has a process to put somebody, a conservator, for 2 full election cycles, well before it could be well before their next election. So it's just a pattern of, instead of going through more preventive measures, going to punitive measures, and also the burden of proof that the threshold for putting those requests is very low. The threshold to, if the requester doesn't find that adequate, there is no threshold how much additional information, like why exactly didn't specify. There is no specificity saying that they have to detail exactly why the request was not accepted. So it's too broad. It makes a pathway, even though there's a couple of steps and it's a little bit less broad than the original bill. It's so broad that can open up for abuse and is just not going to help anything. It's going to just make things worse.
Thank you, Dr. Carranza. Members, any questions? Thank you. Good to see you. The chair calls for a cameo appearance, Emily E.B. French. Yes, she's here. Have you been over there tweeting this morning? Okay.
Always.
You are Emily E.B. French, and you're here on behalf of the Texas Civil Rights Project and against SB 1039. Is that right?
All correct.
Thank you. Go ahead.
I'm here to oppose SB 1039. Like the other state takeover of elections bills, we oppose this attempt to impose state control over local election administration. Unlike some of the others, this bill allows the Secretary of State to effectively remove election duties from both locally appointed EAs and county clerks who were duly elected by voters. We also think the procedures in this bill are really poorly outlined. Section 280.001E designates the requesters who would be entitled to force election officials to drop everything and respond to their demands. If this had been law in November 22, that would have designated at least 1,746 people in Harris County wielding this power over election officials. It would have been 1,100 people in Dallas County, 800 in Tarrant County, 324 in Williamson, and 100 in Grayson. It's a lot of people who would suddenly have great power over local election officials. The requester process in 1039 is full of uncertainty. It doesn't contain sufficient guardrails to prevent abuse. It does not require a good faith or objectively reasonable basis for believing that there's a problem in the first place, nor does it require that the requester be genuine or reasonable in being unsatisfied with an election official's response. SB 1039 provides no options for a county official who's done everything they can to produce the most complete answer possible or who has no records in existence that would address the requester's concern, yet the requester remains unsatisfied. I don't know what kind of documents would explain misplanning for paper ballots in Harris County in a satisfactory manner. Without more explicit guardrails, the best case scenario is that election officials will be subject to routine harassment from partisan actors. Couple more things. I don't believe this is targeted enough. I think the phrasing encourages request fishing. I don't believe it's local enough. State party chairs being involved doesn't strike me as particularly local. Thank you.
Members, any questions? Yes, Representative Manuel. Or Dea Yali. Yeah.
Mono manual.
Sorry about that.
Like a
You guys
like a
are
mirror.
both good-looking people. That's my fault.
Hairline. First of all, thank you for your testimony. Question a little bit in clarification. I don't know if this was what you're saying, and I think I wrote it down correctly, but you said a number of folks, 1,000, 1,700, 1,100 here and there, would have control over their election officials. Are those the people that had called to have an inquiry or have a complaint? Is that the number of folks that have called?
So in section 2, in the bill, it designates, like, these are the people who are entitled to request under this section. And so I got those numbers by adding up how many candidates were there and election judges.
Okay, so that's the whole universe of people who could make an inquiry as to an irregularity.
Correct.
And in the grand scheme of the voting public, that's a pretty small group, fair to say?
I would say that the entire voting public can make open records requests.
Not under this statute, not under this bill.
And under this statute, I still think that it is judges and alternate judges at each election site. That seems to me to be targeted to make sure that both major parties get a chance to ask questions at every single polling place when they could already do that through ORRs or candidates or party chairs.
And I get it, but again, this bill to me reads to be targeted to folks that are in the process, that are, in the system, can go and utilize this process. Am I reading that right?
I understand it that way. I think that answering, if all of those people, if half of those people file only one request, I think it would still be incredibly overwhelming in terms of investigations at the county.
Okay. And that's probably unlikely, though, you think, statistically.
I think anything could happen in Harris County.
Apparently.
Mark, I don't know where you get that from. Thank you.
Thank you.
All right, members, any other questions? Thank you very much.
Thanks.
The chair calls Alexei Swirsky. You are Alexei Swirsky, and you're for SB 1039 testifying on behalf of yourself. Is that all correct?
Correct. Can't quite reach this microphone. Can you hear me?
Yes, ma'am.
Okay. I support Senate Bill 1039. I have served as both a presiding judge and alternate judge and as a poll watcher. I've regularly observed election irregularities. I'll tell you about a few of them. It is rare, very rare, that anything is done about them. In one election in which I was the Republican alternate judge, the presiding judge actually told the poll watchers they had to stay across the room from the election area in violation of Texas election law. In response to a call from the Republican Party, a Harris County attorney came to the poll and tried to talk to the judge. The PJ spoke with him, presiding judge, but wouldn't agree to abide by Texas election law and allow the poll watchers to stand behind the sign-in area and observe voters checking in, which is totally legal and spelled out. In order to avoid further interaction with the county attorney, the very tall judge literally ran out the front doors of the polling area and across the parking lot, weaving around voters' cars. I'll never forget that sight. The attorney then left the poll. The presiding judge came back inside, and she continued obstructing the poll watchers for the rest of the day. At least she didn't body bump a petite college girl poll watcher again, as she had done earlier in the day. One thing I would correct about this is to please allow poll watchers and citizens and election clerks to also report election violations. A friend of mine was a poll watcher in the Acres Homes area of Houston in the November election. The PJ, the presiding judge, and alternate judge were married to one another. It's unreasonable to expect them to turn one another in for election irregularities. In fact, it's not unusual for all of the judges and clerks to be of the same party. They're not going to squeal on one another.
Thank you, Ms. Swirsky. I think you're out of time. I appreciate your comments.
Thank you.
Members, any questions of Ms. Swirsky? Appreciate your information. The chair calls Rosemarie Clouston. Did I pronounce your last name correct?
You did not, but that's okay. Rhymes with Houston, Clouston.
Clouston, Rosemarie Clouston, you're here on behalf of yourself and you are against SB 1039, is that right?
That's correct.
Go right ahead, ma'am.
Thank you. So I'm testifying today on behalf of myself, but for 3 years, including the 2020 and 2022 elections, I was the voter protection director for the Texas Democratic Party. In that role, I've called many elections offices throughout the state and have had these conversations. And the way that Mr. Davis described these conversations and the way that these issues work now is generally how that happens. I agree with the alleged intent of this bill to improve transparency and responsiveness of elections offices, but this bill's methods are severely misguided and will have many negative impacts. I wish it could be up here supporting good faith efforts to ensure transparency so that I can better serve voters and ensure that their right to vote is preserved, but that's not what happens here. This bill opens up our election officials to many complaints and requests for detailed, exhaustive explanations of procedures that take valuable and extensive resources, likely during critical times when they're already working 24/7. When I don't get a call back during the election period, I know that most of the time it's because our elections offices, especially those in small rural counties, are making really difficult prioritization decisions because they have one or two staff who are working 24/7 already, and they're deciding, do I get the mail ballots out, do I prepare my election clerks, or do I call back about this issue? Which maybe they already have information about whether it's been resolved or what happened there. And while I would love to know that, that is not the highest priority. Voters getting their right to vote and having that in their process work right is the highest priority. And we seem to lose that a lot in these conversations, that really our focus needs to be on the voters. I'm also worried about discrimination in the implementation and enforcement of this bill, that the Secretary of State will follow through on, find validity in, and appoint a conservator to replace an election administrator or clerk who wholesale on problems that this partisan official is more concerned about, meaning the Secretary of State, as opposed to those that disenfranchise and intimidate voters, like poor training that leads to voters not ending up on or being removed from the rolls, or discrimination against Black voters like we saw litigation around in Jefferson County in 2022. The SOS has broad judgment and latitude in the bill that goes too far.
Chair calls Andrew Hendrickson. Good morning, Mr. Hendrickson. Good to see you again. You're here on behalf of SB 1039. Is that all correct?
That is correct.
Go right ahead.
All right, so first I just want to start with a point that's been raised, but a sort of different angle on it, this not satisfied standard. Someone can make a request, 20 days later you have to respond just because they're not satisfied. 10 more days go by, it gets kicked up to the SOS because they're not satisfied. I think, one, we've heard a lot about the time and effort that would take for elections administrators. I also think that, that is going to distract from their primary purpose of administering elections effectively, especially because there are civil penalties that can be leveled for failure to correct a violation. And that also will take funds away from their primary purpose, which is administering free and fair elections. But I think the bigger problem there is that partisan actors are going to be enabled to weaponize this. So if the state party chair for the Republican Party issues 254 requests for more information, you know that the Democratic county party, state party chair is going to do the same. That will happen on the county level. That will happen between presiding judges and alternate presiding judges. This is going to ramp up the number of requests for these that happen, especially because right now, complaints that go to the SOS's office don't necessarily trigger any action. That goes to also the cost of the state. That $6.1 million FN that was mentioned earlier is based on the current number of complaints that are received. It will go up dramatically if this bill passes. It also doesn't account for the fact that the committee substitute did change the conservator provision from a shall to a may, but it also made it whole counties, whereas that FN was based on single precincts. Conservatorship is actually our biggest issue with the bill. The may section of that would allow the SOS, in the Secretary's discretion, without even completing an audit, to find that a violation had occurred. And because they made that permissive in the Senate committee substitute rather than a shall, there's a massive problem with abuse of power here, where you could take over a whole county at the discretion of the SOS.
Thank you, sir. Representative Busey.
Thank you, Mr. Chair. Sorry. No, I just wanted to elaborate on that one point real quick. By making it a may, will that potentially lead to inconsistencies across the state with how it's being decided by from a partisan office?
Absolutely. There is nothing in the bill that gives any guidance as to why one county would be put under conservatorship and another would not. It's supposedly forward-looking, but, if we've seen a county like Harris be, beat up in this committee a lot recently, I think there's an issue with, if the same violation were to occur in Harris County in the next election cycle, 2023 being their big mayoral election where they are going to have a lot of turnout, and, 1750, which we heard last week, goes into effect, you'll have a county clerk who who gets power over that on September 1st. So I think you're going to see issues if that happens. I think what you're going to have happen here is an issue where the same violation could trigger conservatorship in one county, but not in another county. And that is completely left up to the Secretary of State's discretion.
For this, just to get it right, you said the same violation, they could approach it differently.
Absolutely.
from county,
There's nothing in the bill
based on
preventing that.
their choice. That seems not like the best path forward. Thank you.
Members, any other questions? Yes, sir. Representative Day Ayala.
No, Capriglio had a question.
Oh, I thought it was you.
It is me, it is me. But real
Man
quick,
alive, all right.
so you're, real quick, your testimony today is the Secretary of State could grade people's papers differently in different counties, something along those lines, right?
Or they could grade them the same and have a different result, right? I mean, you could identify the same violation in both. You could say that there were deficiencies in both and yet put one under conservatorship and do nothing about the other than send them a notice to correct the violation.
And I think you couch that into terms of abuse of power, right?
Yes.
Okay. What this bill is trying to get at some level is somehow to provide some process for a limited group of folks to try to get some resolution to issues, irregularities, how it's couched here, and a process to do that. And then at the end have some result if the process isn't met. And I think at the end result is this possibility of a conservatorship. Am I generally describing that the way you understand it?
I think I mean, I don't know exactly what the question was there, except...
There isn't one. Just, that's kind of the
Okay.
first part. I mean, generally, we're on the same page, then my question is coming.
Okay.
And my question is this, is you talk about an abuse of power at the Secretary of State, and this may or may not be a bill and ultimately a statute that deals with an abuse of power locally, but it could encompass an instance where there has been an abuse of power locally, and the natural consequence is for the Secretary of State, who's responsible for elections in the state, to have some oversight over that. Now, just contextually, that's how you understand how this process is supposed to work at some level.
That's correct. Currently, there's $27.9 million in the budget for statewide election administration for the SOS, that's Strategy B1B of Article 1 for the Secretary of State's funding. This bill with its $6.1 million fiscal note, which I actually think is low. I disagree with the Secretary of State's office on that because I think the number of requests would be massive. I think when you're looking at that fiscal note, we're talking about putting 1/4 of the resources that they currently have, approximately, with 6.1 million of that 27.9 million, almost 1/4 of the resources towards this process and this process alone. And so you're also, I mean, I also think, one of the sort of pushbacks I would have on this general categorization of this as simply putting someone at the state level in charge. You're not only just putting someone at the state level in charge of this oversight, you're putting a member of the executive branch in charge of this oversight. And you're potentially having counties that are under conservatorship where the governor would be on the ballot, whether that's a Democratic governor in the future or a Republican governor now, where the governor would be on the ballot and have the power to basically at their discretion put counties under conservatorship where the situation is not favorable to them. Under conservatorship, you could be talking about putting polling places in, Republican or Democratic heavy areas, and it just leads to all sorts of problems that we like to try to prevent preemptively, right? I mean, I'm not saying that they're going to happen or that anyone's going to do this now or that we have any evidence that this is happening. I'm saying that this is something we need to make sure there are guardrails so that it can never happen.
Good points. Representative Capriglio.
Thank you, Mr. Chairman. I wanted to talk to you about a couple of things that you mentioned, which is the standard of reasonably satisfied and the fiscal note. But since you mentioned fiscal note last, I'll start with that, which is, I think I agree with you. I think if you look at the number of people that could complain, which I would categorize as everyone who lost, okay? And when you tie that with a standard, which I would say is not sufficiently defined, this could cause just, I don't see how the resources needed for this would be almost unlimited, right? I mean, you just say, I'm not ready, I don't agree. I thought there was 10,000, I thought there was 9,000, I thought there was 8,000. There's a lot of people who would do that, and you would have the other side. I guess if you could tell me what you think the standard is under this bill in terms of what is reasonably satisfied to someone who lost and doesn't agree with the outcome?
I think you have to put some sort of legal standard about reasonableness and the ability for I think it's problematic to run through any of these situations, right? Other than just running through the current process through the PIA request. And, I think with the PIA request, we have processes in place to make sure that the requests are reasonable, that it's information that is valid and, is public and can be shared. Sometimes I know that doesn't go as fast as people would like, but I think the way to fix that is to look at ways to change the PIA law. If we want to make more transparency, we have a system for that. This is a way to get around the current system and just in the area of elections force a lot of information to be produced by local elected officials and create a lot of work for the Secretary of State, because even if they don't conduct the audit, which is a may, they do have to engage in the review process. Based on the 300 complaints, what the fiscal note says is that it's 4 full-time employees in the forensic audit division, but 2 additional full-time employees just to review the requests for an audit as they come in. That's based on the 300 complaint mark. And I just don't think that number is anywhere close to accurate.
And that's just on the state side. There's still that.
Right, and then you still have the local side where you're going to interfere with the primary functions of these offices, which is making sure that everyone is able to access the ballot, the polling places, and have a smooth, fair, free election. And so many of those resources are going to be devoted instead to responding to endless requests for more information. And because there are really tight time frames and everybody gets 2 bites at the apple with the 20 days and the 10 days, it's going to inundate these offices with an endless number of requests. And like you said, from everyone who lost, but also from state party chairs, county party chairs, partisan actors who have an interest in this question, not because they have an interest in an actual race or an irregularity in a race that they were in, but because they really just want to call out the system for their own ends in certain areas, certain counties that don't tend to break their way.
Thank you, Mr. Henderson.
Of course.
Thank you.
Members, any other questions? Thank you.
Thank you.
The chair calls Katya Arisman. Ms. Arisman, good to see you. You're here on behalf of the Common Cause of Texas and yourself, and you're against SB 1039. Is that all correct?
Yes, sir.
You go right ahead.
Awesome. Thank you so much. Well, our big concern with SB 1039 that hasn't been already articulated is kind of twofold. First, again, the injection of politics into the audit process, and then second, the danger for a lack of appeal and challenge process from the counties if the investigation, audit, or conservatorship comes into play in the steps of this bill. As mentioned kind of already, there's already a process in place through the PIA, which could be reformed, or through the election audit unit, which already has an allotment of $4 million for their investigations, which has been found to have only produced 5 convictions over the 2-year period, which I think we've talked about in a previous bill a few weeks ago. But this bill allows, as Andrew was mentioning, losing candidates, primary challengers, state and local party chairs to request these investigations with, again, a low threshold for requesting investigation from the election administrator or the county, and also no penalty or fine for if this request for investigation is frivolous or baseless or unfounded in evidence that they're bringing to the county to request that claim. The additional civil penalties is already also a problem on already underfunded elections offices, especially when it accounts for smaller and rural counties. And the fiscal note has an indeterminate cost when it comes to local government offices, which is an additional concern for us, again, when you bring in those primary challengers, those local chairs into account, because they could, request those investigations within the certification period when counties are already overwhelmed by the certification of ballot results, and may have to take that extra day after the 20 or 30-day window, causing an additional $500 penalty already accumulating on their responsibilities, and no allotment for financial costs for additional staff on the county level to actually go through these investigations, which is an additional problem. Overall, I think county officials would be forced to review. There's also no accountability for if the conservator re-engages in new problems in the election, and no ability for us to remove that conservator or for the county's elections commission to challenge that conservator's role, and they'll be there for 4 years to potentially oversee other elections. So because of the costly burden of proof and the partisanship injected into the process, we urge opposition to the bill.
And there it is. And members, any questions? Thank you, Ms. Erisman.
We'll support one of these days.
You over here? I can feel it coming.
Yeah, someday today.
Are you also over there tweeting?
We've tweeted some.
Okay,
Yeah,
all right,
yeah.
all right, making sure.
The public's got to know, you know?
Yeah, they gotta know. The chair calls Linda Curtis. Ms. Curtis, you're here on behalf of the League of Independent Voters of Texas and yourself, and you're against SB 1039, is that all correct?
Yes, sir, and I swear I have not tweeted at all this morning. But I'm getting ready.
Good.
Thank you, Representative Capri-Leon, for your very astute questions. I want to give you a hug. We do not like SB 1039 and see it as a solution in search of a problem, serving really to undermine, not strengthen voters' trust in our election system. Moreover, it appears to us that the motivation for this legislation is to continue to drag each and every Texan, regardless of party affiliation, into the never-ending war between the two parties for control of Washington, moreover, Harris County. Texas independent voters, there are millions of us. We would like to get out of the crossfire and are urging you to take us out of the crossfire. We're watching and we're growing. Do you really want to give us a tool to organize in local communities, especially rural, where people know and trust their election officials? So go ahead, make our day, but I hope you don't.
Thank you, ma'am.
The rest of the testimony is written. Thank you.
I appreciate you. Members, any questions of Ms. Curtis? Thank you so much. The chair calls Luis Figueroa. Hold on, Mr. Figueroa, I'm having a hard time with my computer here. You are Luis Figueroa, you're here on behalf of every Texan, and you are against SB 1039, is that correct?
That's correct, Mr. Chairman.
Do you have anything new to add to this discussion?
Very little. I'll keep it short.
Go ahead.
Thank you, Mr. Chairman. Luis Figueroa with every Texan. We are in opposition to the bill. We are okay with audits and accountability, but we believe when you do have accountability and audits, it should be funded, it should be proportional, and it should be fair. So first of all, on the funding part, I used to work in the Senate. You all may remember the Nelson rule that if it wasn't in the budget, then the bill shouldn't be moved. We don't believe this bill is funded yet in the budget. So we want to make sure it's funded both on the statewide side, but also we should consider some support for the counties that are going to have to respond to these complaints and make sure that they're in compliance. So I think there's a two-part question there on the funding. On the proportionality side, I think that's pretty been well covered, but I would agree that when I did election protection work, as you pointed out, Mr. Caprileone, that there was a lot of complaints, anecdotal complaints that we would then investigate, and then turned out that it was did not really bear out, and it was usually the losing party who usually had these anecdotes of complaints, and the complaints were pretty wide-ranging we even got complaints about not enough stickers, not enough paper, not enough whatever, and so a lot of these complaints sometimes are pretty anecdotal and not really based on reality. And then the last thing I'll just say on fairness, I think that's been pretty well covered, is the amount of power to the Secretary of State here and the legal standards on there. I don't want to reiterate everything, but we are concerned that giving the Secretary of State that much authority to determine all of these without any guidelines is pretty concerning. That's kind of why we do it in the courts, so that there's an impartial evaluator with some evidence and rules of engagement, so to speak. So how are we going to do this in the Secretary of State's office? I think at the very least we could provide some more legal standards for the Secretary of State and clear that up a little bit.
Thank you.
That's all I have. Thank you so much.
Members, any questions? Thank you, Mr. Figueroa.
You got it.
Good points. The chair calls Laura Martinez. You are
Hello.
Laura Martinez. You are here. For some reason, this thing, I can't get that out of my way here. You're here on behalf of yourself, and you are against SB 1039, is that correct?
That's right.
Go ahead.
I'm here to testify in opposition to Senate Bill 1039, which would allow for partisan influence over nonpartisan election offices. I'm the proud spouse of retired Chief Warrant Officer 4 Richard Martinez, and his career in the military meant that our family spent many years living overseas. As a part of the U.S. military-connected community overseas, I voted via absentee ballot. When serving overseas, it takes additional time and effort to stay informed on local politics and to cast one's ballot. It also takes the local election offices additional time to process these ballots. Senate Bill 1039 would add even more responsibilities to already underfunded election offices managing these different types of ballots. When our family returned to Texas in June 2021, I was eager to learn more and to get involved with my local elections. During the fall of 2022, I worked with the Travis County Elections Division and found the management and my colleagues to be highly professional, focused on continual improvement, efficiency, and dedicated to ensuring accessibility of voting for all registered voters, regardless of party affiliation. For example, I witnessed firsthand the commitment to ensuring that absentee ballots were handled with care, triple-checked, and recorded correctly. I urge the committee to oppose Senate Bill 1039 because it would undermine our local elections offices and bring a partisan nature to what is currently nonpartisan by design.
Thank you, ma'am. Members, any questions? Thank you, Ms. Martinez. Chair calls Ken Moore. Good to see you, Mr. Moore. You're here on behalf of yourself and your 4 SB 1039, is that correct?
That is correct.
You have anything new to add to this discussion?
Not a lot, but I'd beg you give me, I try to keep my testimony short.
We are going to move on through. Go ahead.
Okay. So, well, two things. You've already heard testimony ad nauseum about the problems they had in Harris County and in Dallas County and other areas. And I'm not going to go through all that again.
Thank you.
But you've also heard today a lot of testimony about what might happen if this bill passes. I would be more concerned about what is happening, because you do have irregularities taking place, and you do have shenanigans happening, and you do have closed-mouth officials refusing to answer questions. And that's going on right now. This bill forces those tongues to loosen up and to give answers to the questions that are being asked. And so I ask you to please pass this.
Representative Capriglio.
One quick question, Mr. Chairman. So the bill basically has a small list of individuals who can make a complaint. Do you believe that only a small number of people should be able to be afforded this process, or do you believe that every Texan should be afforded this process?
That's a hard question to answer, because that gets into the concerns that have been brought up about, a number of people who all has access to it, how many people could.
Well, do you believe that someone like yourself or any other Texan constituent, a voter, citizen, should be allowed to be afforded this same sort of review, or should it only be for a select few?
I can see an argument both ways. I would say that I would like to see it done for every Texan, but I can
So
also,
that every Texan could.
But I can understand the concerns about this flooding. When you're limited to candidates, you're limited to election officials, judges, people who work the elections. I think that's probably more common sense. If someone is just a normal Texan voter, you can go to a judge. You can talk to what's going on. You can go to the candidate and talk to what's going on. I would, like I said, I can see the desire to have every Texan have access to this. But in that case, I would share the concerns that have been brought up about flooding it. By keeping it just to those officials who actually work with the elections and who see what's going on and those who are affected by it, I think that's probably a more common sense way to do it.
Thank you.
Thank you. Members, any other questions? Thank you, Mr. Moore. The chair calls Joanne Richards. It's good to see you, Ms. Richards. You are Dr. Joanne Richards here on behalf of yourself and against SB 1039, is that correct?
That is correct, and I don't have much more to add, but I am a former election judge, and I know how diligently election administrators and county clerks work under very tight deadlines in order to have fair, safe, and accurate elections. And SB 1039 provides no appeal process and no protections to ensure that the Secretary of State's decisions are impartial, fair, and lawful. As an appointed position, the Secretary of State is not accountable to voters. I urge the Elections Committee to oppose 1039 because it's an ill-conceived bill with an unfunded mandate that will cost taxpayers dearly. It represents an ineffective cost burden on local elections administrators and election clerks all over the state, in rural and in urban counties. I can also state that I can remember what happened a couple of years ago when we were talking about election fraud, and all of a sudden the number of election fraud cases that were brought skyrocketed. And in fact, the investigations found that there was very little to no election fraud at all. And I can see that this particular bill, without having any guardrails, could cause the same problem. Thank you very much.
Thank you. Members, any questions? Thank you. The chair calls Amber Mills. Ms. Mills, you're here on behalf of Move Texas Action Fund and yourself, and you're against.
Yeah, you're good.
You're here on behalf of yourself and Move Texas Action Fund, and you're against SB 1039, is that correct?
Yes, that's correct.
You go ahead.
Our concerns with this bill can be simplified down to 3 C's: complaints, conservatorship, and cost. I am going to skip over complaints because I think y'all have heard enough about that. But these complaints can also lead to a county being placed under a conservatorship decided solely by an unelected partisan actor. Move Texas has worked with election offices across the state to implement innovative and popular reforms. If counties were placed under a state conservatorship, it is very likely that popular local initiatives that increase access will be prohibited or adopted with greater reluctance. We don't want to poison the well of well-intended improvements in civic engagement. We elect leaders at the local level and trust them to make decisions that are best for our community. What works in one county may not work in another. SB 1039 ultimately threatens the power of our votes by allowing an appointee of the governor to have unilateral, unchecked power over elections. Lastly, SB 1039 will likely have severe consequences on already underfunded elections in the state. The resources that it will take for local elections staff to deal with the conservatorship is time and money taken in the wrong direction. We need local leaders to feel empowered to enact creative pro-voter measures, not strained and stressed by partisan political gains and legislative attacks. Thank you.
Members, any questions? Thank you. Ms. Mills, appreciate you. The chair calls Lucy Traynor. Ms. Traynor, you're here on behalf of yourself, and you were for SB 1039, is that correct?
Yes, sir. Good morning, Chairman. Good morning, members. I'm also have the party hat right now. We ran a Protect the Vote program that answered.
But you are here
several
on
calls.
behalf of yourself, huh?
Yes, sir. Yes.
Okay, go ahead.
So citizens don't really feel listened to by the local election offices when bringing up legitimate concerns, and of course don't have thousands of dollars to petition the local court system, which ends up being the only alternative in most cases. Eventually, these activists and the electorate at large feel deeply defeated when legitimate questions go unanswered or not answered well by election offices, violating a profound sense of justice and fairness. Many times, activists either choose to walk away after helping in elections or stay and get even angrier with the system they feel has little accountability and transparency. We believe this bill will increase voter confidence and give election workers and candidates a new sense of understanding and assurance, as there will now be a guided and coherent system in place to resolve election irregularities outside of the courtroom.
Thank you, ma'am. Members, any questions of Ms. Trainer? Thank you very much. The chair calls Charles Cruz. Mr. Cruz, you're here on behalf of yourself and you're against SB 1039, is that correct?
That's correct.
Do you have anything new to add to this discussion?
I believe so, sir.
Go ahead.
So my name is Charles Cruz, coming from Baytown, Texas. I'm a retired chemical engineer, and what we do as engineers is analyze the machines and improve the output. You have an input, you have a machine, you have an output. This bill seeks to complain about the output but does not fix the machine. This bill is very poorly written and does not work to better elections in Texas. It should be voted against. I'm asking y'all to vote against it because we need bills to improve elections in Harris County and Texas in general.
Thank you, sir.
Not complain about stuff after the election.
Members, any questions? Thank you, Mr. Cruz. Appreciate that. The chair calls Brenda Cruz.
Good morning.
Ma'am, you're Brenda Cruz. You're here on behalf of the Texas Democratic Party and yourself, and you're against SB 1039, is that correct?
Yes.
Do you have anything additional to add to this discussion?
I'm actually going to keep it brief because I think my colleagues have mentioned a lot of the same things. I do want to highlight one specific thing that I heard, just because I do have personal experience within my capacity, was that there are times when there are inconsistencies going on in the county and they feel that there's not a lot of a quick enough response going on. One of the issues that I saw firsthand and tried to resolve last year during the 2022 election was as a result of the redistricting that the state went under, the voter file was not always accurate in Webb County. So some folks would go in and look at their polling place and it would show them in like the wrong precinct because precinct lines were redrawn. I found that the elections office was incredibly responsive. They were very diligent in trying to get it resolved. They were in constant communication with the Secretary of State. It was a months-long process to get this fixed. But the way that I look at this bill is that it would allow thousands of people to be able to inundate one elections office with complaints and not give the elections office sufficient enough time to respond to these claims, especially if these complaints are coming in once voting has started. I think that is one of the things that we really need to look at. Fundamentally, for democratic elections in this country and in the state of Texas, the ultimate goal is to make sure that every single eligible voter can cast a ballot that counts. And if we are inundating these elections offices with these kinds of claims, voters are going to be hurt once voting has started. Thank you.
Members, any questions? Thank you, Ms. Cruz. The chair calls Cindy Siegel. The chair calls Cindy Siegel. Cindy Siegel, I show her as testifying for SB 1039 and is she? Okay. We are going to finish this bill quickly. Ma'am, you're Cindy Siegel. You're here for SB 1039 and you are testifying on behalf of the Harris County Republican Party, is that correct?
Yes, I am.
I appreciate you being here, but do you have anything new to add to this?
Well, I think so. During the last legislative session, you passed SB 1 that requires a reconciliation report to be signed off by the central count presiding judge, filed with the Secretary of State. This reconciliation report helps identify problems with the count, but it doesn't always answer the question of why. You've heard for months testimony from several different people about how badly Harris County mismanaged the elections last year, from the primary to the general election. We know what went wrong, but Harris County still refuses to answer the basic question of why. For example, today, if you go to harrisvotes.com and look at the election reports, you will find the official reconciliation report for the November 8th election. It shows 9,307 more mail ballots being counted than being returned in the mail. It doesn't show up in the unreconciled difference, but it shows up on that reconciliation report. When brought to the EA's attention, he submitted a report to the Commissioner's Court and Elections Commission in January that changed the reconciliation report 2 months after the official reconciliation report.
Ms. Siegel, I understand. We're
Can
talking about the details of this particular bill.
Can I go on?
The problems. Well, do you have anything specific?
Yes, sir, I do.
Yes, please go ahead.
So what's at issue and why I just heard about Allen, so I'm kind of upset.
Go ahead.
Senate Bill 1039 provides a procedure that allows, as you know, candidates, election judges, and both parties' leadership to get answers to questions. And when an EA or a county clerk has failed to respond, filing an election challenge or suing the county EA or county clerk should not be the candidates or the party's only recourse for getting answers and transparencies. In regards to some of the other testimony on the conservatorship, the reality is if you put in a conservatorship, they have to follow the election code too. There's all this reference to that they're going to overstep. Secondly, they talk about, well, you shouldn't have the Secretary of State have oversight, that's a one-person appointed position. Right now in Harris County, we've got an election commission that I'm not reporting to the voters, so there's no other recourse. We talk about the cost of this. Well, what about the cost to the candidates? What the cost of hundreds of thousands of dollars that our party has had to file to get basic answers of why and to get it cleaned up in Harris County. And that's why I support that bill.
Points well taken, Ms. Siegel. Thank you. The chair calls Stephanie Swanson. Ms. Swanson, you're here on behalf of the League of Women Voters of Texas and yourself, and you're against SB 1039, is that correct?
That's correct.
Do you have anything new to add to this discussion?
We have two things to add. While the bill defines the persons who can make a request, it does not require that those persons have any connection to a particular polling location or precinct. This raises a possibility of targeting particular communities, including communities of color. We are also concerned that the head of political action committee is one of the individuals granted authority to make a request for explanation. This provision would potentially expose our election system to a range of national actors that want to influence and possibly even challenge the election results. That's all I have to add. Thank you.
Thank you, ma'am. Members, any questions? The chair calls Valerie DeBille. Valerie DeBille. Valerie DeBille, I show her testifying against SB 1039 and on testifying on behalf of herself, and I'm not here. Is there anyone else who wishes to testify on, for, or against Senate Bill 1039? If not, the chair invites Representative Toth to close.
Both those that testified for and against this bill today acknowledged that we have a transparency problem. But if there's no ability to look at the results in a fair way, it's impossible for us ever to believe and trust in our elections. With that, I close.
Thank you, sir. Members, any questions of the representative? Thank you so much.
Thank you, guys.
Steve, good to see you. If there is no objection, Senate Bill 1039 will be left pending. There is no objection. Senate Bill 1039 is left pending. Does he know? No. They do know. Is that what he said? Hey, Dale. At this time, I hate to have to announce this. The chair is personally moved by this news, but we just received word that our friend and colleague Alan Vera has passed. He passed here at the Capitol, apparently. That's the best information we have. His family does know. That's the reason why you've seen quite a bit of activity up here. And we wanted to make sure before we made this announcement that we had confirmed that it was true and that his family knew. But at this time, I'd like for us all to stand and have a moment of silence in memory of our friend Alan Vera. Thank you. I think Alan would want us to continue on our work. We do have to go to the floor at 10. I'm trying to manage that with no offense to Representative Paul, but we're going to go ahead with Representative Hayes's bill. And the chair lays out Senate Bill 924 and recognizes Representative Hayes to explain the bill.
Thank you, Mr. Chairman and members of the committee. Under the election code, currently there's a maximum of 5,000 registered voters per voting precinct, and sometimes in larger communities, they have no facility within the precinct that can serve as a polling location. An example of this is in many retirement communities, they have one amenity center, which may be used as a polling location, but there are really no other locations in the community to vote, and therefore the citizens are not able to vote at a single location. This bill seeks to remedy this issue by allowing counties with a population of up to 1.2 million to combine on election day only 2 or more county election voting precincts on the recommendation of the county election board if there's not a facility available to use as a polling location.
Members, any questions? All right, quick question for you. Has there been any thought of what this could do for college campuses? We've been brought with the concern that when we're combining, is there any protection or safeguards around college campuses in this bill not losing their site?
Well, the election voting precincts will be the same. It's just saying on election day, if you've got one precinct here and one precinct like next door, they could have a single polling location. Take like in a retirement community, this is how this was brought to us, Robeson Ranch. They've grown over the years now. They're split into 2 polling locations. If they have a single amenity center, you know, like the clubhouse where everybody used to go vote. And so now that they had to be split, there's an inconvenient another location outside of their precinct to vote. So I think, and to answer your question specifically, it would allow, if you had a large campus, everybody to vote at the same location. Maybe it's a student union building or some other.
I hear you. I appreciate that. I just would love to be able to work with you if we could, just to make sure, since college campus, so many kids don't have transportation, we'll make sure we're, you know, securing and protecting that right.
And I think, Vice Chair Busey, this would make it easier. There could be one place on campus where everybody could come and vote.
All right. Members, any other questions? Thank you, sir.
Thank you.
We'll reserve your right to close. Chair calls Katia Harris. Katia? Aerosmith.
Ms. Harrisman, you're here on behalf of yourself and Common Cause Texas, and you're against SB 924, is that right?
Yes, sir.
Go right ahead.
Thank you. And actually, I appreciate the question and the layout because that was largely our concern. We've seen historically that when consolidating polling precincts has happened, there's been a dangerous precedent and expected outcome where there's less accessible polling locations, longer travel times, or what's happened when you've consolidated precincts is occasionally it'll, make only one polling location in what's referenced in the bill analysis of, one retirement community getting one location as opposed to 2, which is a concern as to why we have, worry about the carve-out, the lack of carve-out for college campuses, potentially UNT or UTRGV, which would be covered by the bracketed counties in the bill. The bill also creates the potential adverse and unintended consequence, which could be, a polling location that's selected in the consolidated precinct and by this county and by the county commissioner's court being, not the preferred or accessible one by the community or not the community location, which members have, routinely visited and used as their polling location for a long period of time, which we know has an adverse reaction on people not being inclined to go vote or not knowing that they can have another option to go vote because they're used to going to that one location. We've also seen that when left to commissioners' courts, for example, the polling location allotment on that college campus, if it's in that neighborhood where the consolidated precinct is happening, because typically that's where that fastest growth is occurring in those neighboring, precincts and neighborhoods around a campus precinct, would, not necessarily prioritize putting it on the student's campus because we've seen commissioners' courts not listen to students in the coverage of the location allotment. The concern is not necessarily conjecture. We hope there's neutrality in these decisions. A report in 2019 found that when counties transitioned or consolidated locations, many of them were closed in Latinx neighborhoods or Black and brown neighborhoods. And so we're just worried that at any point this bill might close or limit polling locations. And historically, that's not been a helpful solution. So we would urge the committee to oppose this bill.
And just to make sure we got the record right, you're Katia Harrisman, you're here on behalf of yourself and Common Cause Texas, and you are against the bill.
Yes, sir.
Right? Thank you. Members, any questions? Thank you.
Thank you.
Thank you, John. The chair calls Robert Green. Mr. Green, you're here on behalf of yourself and the Travis County Republican Party Election Integrity Committee, and you are on the bill, is what I show.
That is correct, sir.
Sir, go ahead.
I have a question for the bill's author. Will this bill, is it designed to affect Travis County?
I'm sorry, what was your
Does
question?
this bill affect Travis County? I don't know the exact vote population total.
Well, we'll get him to answer that question when he comes back up to close.
Thank you so much.
All right, absolutely. Members, any questions of Mr. Green? All right, the chair calls Andrew Hendrickson. That's 2469. Mr. Hendrickson, you're here on behalf of the ACLU of Texas and against the bill, is that correct?
That's correct. I think Katya covered most of what I was going to say in my testimony, so just a couple of quick flags. I don't believe the bill would apply to Travis County the way I'm reading the bracket, but it does apply only to 4 counties. It's unclear why the bracket is written the way that it is, and somewhat suspicious, I think, that the 2 of the 4 counties covered are Cameron County and Denton County, where we have seen shifts in political dynamics recently in both directions for both parties. But the fact that we're changing things that in 4 counties, and those are 2 of the 4 included, just raised an eyebrow for me, and I would like to better understand the bracket myself. I also would point out that we share those concerns about the college campus polling locations, and while these decisions would have to be approved by the Commissioner's Court, we did see in College Station in this past election cycle the elimination of a polling place on the college campus. And that decision was made by the Commissioner's Court during the summer when students were not present to show up and to protest that decision. When they were back in the fall, they did. Some of the commissioners admitted that they thought it was a mistake, but it was too close to the election to change it back. I think just creating this mechanism to close polling places and in the name of consolidation and efficiency, while I understand the argument, I think it's problematic. I think it can lead to unintended consequences, and we generally think that there should be more polling sites, not fewer, and that is why we opposed the bill.
Thank you. Mr. Hendrickson, members, any questions? All right, thank you.
Thank you.
The chair calls Louise Joy. Louise Joy. I show Louise Joy as testifying on behalf of herself and against SB 924 and not here to testify. The chair calls Ed Johnson. Ed Johnson. I show Ed Johnson is testifying on behalf of himself and for SB 924, not here to testify. The chair calls Christina Atkins. Ms. Atkins, you're here on behalf of the Texas Secretary of State's office and neutral on SB 924, is that correct?
Yes, sir.
Members, she's here as a resource witness. May I have any questions of our witness? Do you have any comments about this particular bill? Thank you,
Sir.
ma'am. Is there anyone else who wishes to testify on, for, or against SB 924? We do. Ms. Clueston, Acosta, Rosemary? Ma'am, you are Rosemary Clueston. You are here on behalf of yourself and against SB 924, is that correct?
Yes, that's correct.
Go right ahead.
One area that I would like to see clarification on this bill, there was a dispute in the Senate committee hearing about whether it applied to counties with countywide voting or not. I think we've talked a little bit today that it sounds like it does not, but I think we should seek clarification on that from the author and potentially Secretary of State's office before you all take a vote on this. Additionally, as Katya and Andrew discussed, consolidation tends to negatively impact Black and brown voters disproportionately, reducing access and causing lines. So I'm concerned that there's no requirements for evidence that a polling place was sought and couldn't be found. You know, the author talks about these places where there legitimately is no facility in which to hold an election, which I understand the practicalities of that. And of course, we need to make adjustments and understand that. But we should not use that excuse to allow for broader consolidation of polling places where there are in fact options and where we can have elections there, and therefore would like to see a requirement that there be some evidence presented to the commission, to the election board, that a polling place was tried to be found and couldn't be. For instance, I think the example given in the Senate committee hearing was an HOA that refused to allow them access. So providing that documentation, we asked, they denied our request, and therefore there is no polling place possible in this area, I think would be a prudent measure to ensure that we're meeting the bill's intent without unnecessarily consolidating polling places.
Thank you, Ms. Cliston. Members, any questions? We appreciate you.
Thank you.
The chair, is there anyone else who wishes to testify on, for, or against SB 924? If not, recognize Representative Hayes to close and answer this question.
It does not apply to Travis County, according to my Google research. It seems to me that there's some misunderstanding on the bill. This is not a statewide sweeping, let's try to consolidate all voting precincts. This is a convenience bill. It mainly applies to retirement communities. They have a single amenity center. The bill specifically says if the commissioner's court cannot secure a suitable polling location because the way the community was designed. So it's not a sweeping, let's take every precinct. It also has another safeguard. You can't have more than precincts combined, more than 10,000 registered voters. So I think the sky is falling approach on this bill is unwarranted and would ask that you support it. Thank you.
Representative Busey.
One quick question. Does this apply to countywide voting or just precinct voting for E-Day?
It's precinct voting just on election day.
So counties that do countywide voting, this wouldn't
apply, and early voting, you can vote anywhere. So this is just an election day bill to combine a precinct.
If we meet with the Secretary of State's office offline and they think we need to clarify that, would you be open to clarifying that it's for precinct voting specifically? Counties that do precinct voting on election day, not countywide voting.
Well, sure, because in countywide voting, you already have the polling location.
Agreed.
This bill requires.
Just because of the questions we got, we want to make sure we clarify that.
Yes.
Before.
Yeah.
Thank you. I appreciate it.
Okay.
Sky's not falling.
Thank
All
you.
right. Thank you, Representative Hayes. Anybody have any other questions of the representative? Thank you.
You need it?
The chair is going to leave SB.
Sorry.
If there's no objection, then SB 924 will be left pending. The chair hears none. SB 924 is left pending. Representative Paul, we show 10 witnesses for your bill, and it's 940. We have Representative Bojani here, who has one witness. I appreciate you being here.
Yeah.
I'm sorry. I hate to do that to you. The chair is going to call or lay out SB 4621.
House bill.
It's actually House Bill 4621, and recognize Representative Bojani to explain his bill. Vice Chair Busey offers a committee substitute.
Thank you, Chairman Smith, Vice Chair Busey, and the members of this committee for the opportunity to lay out House Bill 4621. I'd also like to introduce the committee substitute. Imagine that you serve on a school board and your district needs an elementary school. So in February of 2020, you set a bond election for May 2020, having no way to foresee the COVID-19 pandemic coming around the corner. How can you ask your community who have been affected by job loss, financial loss, and even family loss for more money? As a school board trustee, what are your options? Current law allows a political subdivision to cancel an election only for mootness, a term that is not defined anywhere in the statute. If your school district is still needs an elementary school, the measure isn't moot. HB 4621 seeks to remedy this issue by removing moot from statute and providing political subdivisions with a meaningful option to reconsider ballot measures. The committee substitute clarifies the ballot measures can only be reconsidered when a disaster declaration has been issued by the governor within 90 days of the election. To be clear, this only applies to ballot measures, not elected positions. I'm grateful to my colleagues who have signed on to this bill, some of them being members of this esteemed committee. Thank you, Vice Chair Busey, Representative Manuel, and Chairman Capriglione. When disaster strikes, our local governing bodies should have the option to reconsider ballot measures. When Texans are most vulnerable, the last thing that we need them to worry about is about a ballot measure asking them for more money for their taxpayer dollars. Members, it is time to clarify this ambiguous statute and protect local taxpayers during a disaster declaration. At this time, I'd be happy to answer any questions, and I would humbly request the opportunity to close.
Thank you, Representative. Fine presentation. Members, any questions? Thank you. We have one witness, is Christina Atkins. Going to just have you, per our normal deal, have you come up here. You are here on behalf of the Texas Secretary of State's office. You're on this bill, and you are as a resource witness. Members, any questions?
Yes, sir.
Do you have any comments?
No, sir.
Thank you, ma'am. Is there anyone else who wishes to testify on, for, or against House Bill 4621? If not, Representative Johnny, would you please close for us?
Thank you, Chairman Smith, Vice Chair Busey, and members for hearing House Bill 4621. I would humbly ask for your favorable consideration, and I close.
Thank you. Members, any questions? Thank you. Thank you. The committee substitute is withdrawn. If there's no objection, House Bill 4621 will be left pending. Chair hears no objection. House Bill 4621 is left pending. The chair calls Representative Capriglione, or Chairman Capriglione, to lay out Senate Bill 1089 and recognizes him to explain his bill.
Thank you, Chairman Smith and members. Thank you for the opportunity to address the committee. Senate Bill 1089 seeks to uphold the principles of transparency, fairness, and inclusivity in the electoral process by repealing the ability to declare unopposed candidates for office as elected in Texas and clarifying the order in which offices are listed on the ballot. Elections are a crucial mechanism for ensuring the legitimacy of the people's representatives, and allowing uncontested candidates to remain on the ballot upholds the democratic principles of transparency and inclusivity. Excluding uncontested candidates from the ballot can be seen as a violation of these democratic principles and may erode trust and confidence in the electoral process. Additionally, having uncontested candidates on the ballot sends a message to the public that the electoral process is open and transparent, which is essential in fostering truth, trust, and confidence in the system. By repealing the ability to declare unopposed candidates for office as elected in Texas, Senate Bill 1089 ensures that voters have the opportunity to exercise their right to vote and have their say in the electoral process, even in the absence of competition. Moreover, clarifying the order in which offices are listed on the ballot ensures that voters can easily locate the candidates they wish to vote for. Thank you, Mr. Chairman and members. I ask for your support of Senate Bill 1089 and welcome any questions you may have.
Members, any questions? Thank you. I think we just have a couple of witnesses.
Okay. Reserve the right to close.
The chair calls Rosemary Clouston. Ms. Clouston, I show you here testifying on behalf of yourself, and you are
Against the bill.
against the bill. Is that correct?
Correct, yes.
Go right ahead.
So this bill, the law that is in question here was actually changed in SB 1 last session. And the reason that it was changed is because there are long ballots in many of our large counties that force voters to go through screen after screen after screen of uncontested candidates, have contributed to long times that it takes someone to complete their ballot, and then long wait times for the voters behind them. So this measure and the way that the law is now was created to help voters get through the process and to make our elections take less time, more convenient for voters, and to prevent lines at polling places. And I think all of those reasons that you all included this in Senate Bill 1 still stand, and we have seen no problems as a result of this. The author laid out no actual issues that occurred in the last election as a result of this bill. And one of the things that was discussed in the debate on this bill last session was the only real reason for someone to have to vote for a candidate. It doesn't change the outcome, right? Like, this candidate is going to be elected whether a voter votes for them or not, because they are uncontested. The way that our write-ins work, the way that every process that we have in our election system works, that person is going to be elected. So we are giving a voter's false impression that their vote is going to change that outcome by putting them on the ballot, while increasing lines and causing other administrative issues. And it's honestly what was discussed in the Senate committee during that debate. It's vanity for candidates. It's an ego move to see how many votes you got, and that is the only value addition added. There's no value for voters or the process.
Representative Dayal.
Thank you, Mr. Chairman. I was so I looked at this bill, and it made sense to me, and I was curious what was the other side, what was the opposition to this bill, and I was waiting for that, and thank you for that testimony. And what I'm hearing, I think in summary, is other than the ballots get longer, it is more checks for the voter, and may result in some longer lines or add to that problem if there is a problem. Is that all that, are those the only real reasons not to have those candidates' names on the ballot?
Right. When you're balancing the ROI on this, right? The value add is zero. And the problems are those that you laid out, which is longer time that it takes an individual voter to vote and longer lines and potentially longer ballots, which can, change us from what size paper you need to use, whether there's 1 page or 2, and different issues like that do cause other administrative issues for our elections officials.
And you may have been around last session. I was not.
I was.
But was that testified to last session?
It was.
Was there any data associated with it?
I don't believe so, because we didn't have, prior to last session, counties had the option to do this or not. So it was at the discretion of the election official whether they were going to declare those candidates elected and shorten their ballot in that way or whether they weren't. And what we saw was many candidates getting lobbied by uncontested candidates that they wanted to know how many votes they were racking up and, wanted to see that show of support. So they were getting lobbied not to, which led to the change from a may to a shall requirement.
Thank you.
Members, any other questions? Thank you, Ms. Cliston. The chair calls Christina Atkins. Ms. Atkins, I show you're here on behalf of the Texas Secretary of State's Office, neutral on SB 1089, correct?
Yes, sir.
Members have any questions of our resource witness? Vice Chair Busey.
Mr. Chairman.
You, Mike.
Thank you, Mr. Chairman. One quick question. Could this result in a longer ballot? I'm specifically thinking about Harris County and the paper and filling up the ballot. When we go to this, and having to select, does that make the section longer? I'm talking about logistically longer.
It's possible. I will say that under the current law right now, where the cancellation is mandatory or declaring these candidates as mandatory, they still have to be listed at the bottom of the ballot. Voters still have to scroll through those pages now before they get to the end of the ballot and print their ballot. So it may cut down on some time, but the candidates' names are still currently listed, and people have to page through those names.
Thank you.
Anyone else have any questions of Ms. Atkins? Thank you. Is there anyone else who wishes to testify on SB 1089, on, for, or against 1089? If not, we recognize, actually, we do have someone. Okay.
What is your last name?
Van Manen. I'll keep it real quick.
That's right. Good to see you, Ms. Van Manen. You're here as Cynthia Van Manen on behalf of the Travis County Democratic Party and yourself, and you're against SB 1089, is that correct?
That's correct, sir.
Go right ahead.
I just want to say I appreciate the principle of transparency that Chairman Capriglione brought this bill with. Last session with SB 1, there were a whole lot of changes. A lot of people were thrown off by a lot of those changes, but this is one that I, as the executive director of a county party, have heard pretty much unanimous positive feedback for. Ms. Adkins, of course, is right that the names of candidates who are uncontested are still in the ballot, but the space that they take up is a lot shorter. So not only does that help people when they're in the polling place, it helps them when they're looking up their sample ballot. They do still see the names on there, but the whole ballot is a little bit shorter. It helps people focus on the races that they need to focus on, particularly those races that are lower down on the ballot, which are always the ones that get undervoted. So, thank you.
Thank you, ma'am. Members, any questions? Thank you. Is there anyone else who wishes to testify on, for, or against SB 1089? If not, the chair recognizes Chairman Capriglione to close.
Thank you, Mr. Chairman. I would say probably to address some of the issues, I would say people don't really spend a lot of time on the uncontested races, so I don't think we're talking about time, and that's what's making this longer. What I did hear during the elections was a lot of folks who have a list of who they want to vote for, and then they go in there and it doesn't match up. They're expecting certain people in certain positions. They're not there. It causes them to question if they're at the right location, which is what I've heard. I've heard them mention, hey, are you not running again? Are these candidates not on the ballot anymore? So I think all this is doing is going back to the way it always has been, which is having the order of the candidates on the same order on the ballots. With that, no other questions? There is.
Real quick. What I like about it, and coming into it first this session, is it is also a reminder for voters of who their elected official is in whatever spot that is in uncontested. It's just another check and reminder. And that's one of the things that I think if someone's not on the ballot for consecutive cycles, people tend to forget. So,
Yeah, again, I mean, I think to your point, the ballot at the end of the day is a list of their elected officials, and this is the order that they would be in, contested or not. So thank you for that.
Members, any other questions of the chairman? Thank you.
Thank you, Mr. Chairman.
If there's no objection, SB 1089 will be left pending. The chair hears none, and SB 1089 is left pending. Folks, we've got to get to the floor at 10. We did good work this morning, significantly pared down our deal. The chair moves that the committee stand in recess until final adjournment, recess of the House, or during bill referral if permission is granted. Is there objection? Hearing none, the motion prevails. The committee stands in recess.